All rise. The Court of Appeals, Division 1 is now in session.
Please be seated. This is the time set for oral argument in our cause number CR23 0224, State of Arizona versus Christopher Clements. Counsel, we've read the briefs, we've discussed this matter in conference. Keep that in mind as you approach the podium and begin your presentation. We are also video recording today's proceedings, so make sure you announce your name and the party for whom you represent. Each side has 20 minutes for the presentation. Mr. Rossi, if you want to reserve any time, you can, but it's up to you.
No,
all right.
I'd like to reserve 2 minutes.
All right. With that, Mr. Rossi, you may begin.
Good morning, Your Honors. My name is David Rossi. I represent the defendant, Christopher Clements, in this case. No one was defrauded in this matter. The existence of a scheme or plan to defraud the alleged victims out of anything that rightfully belonged to them. There was no scheme or plan to defraud them out of anything that rightfully belonged to them. Christopher obtained a benefit, never obtained a benefit through some false pretense, as the state claimed, nor from a misrepresentation, promise, or via a material omission. What the evidence established was this: concerned that if Melissa deposited her money into his jail spendable account, he might not be able to use it for the purchase of commissary items because it could perhaps be seized for an outstanding child support order. He instead told Melissa to deposit the money, which altogether amounted to $285, into his cellmate Macias's account so that Macias would hopefully purchase items for Christopher.
So does Mr. Clements agree that that money was being held by the cellmate for his benefit?
It was being held with the expectation that the cellmate would buy things for him, yes.
It was not given to the cellmate so that it would be the cellmate's money to do whatever he pleased with?
Well, the testimony in the trial was that the cellmate had the money, and he testified that if he chose to, he could use it for whatever he needed. But there was an understanding between the parties.
So the cellmate could use it for whatever he wanted, or he was only supposed to use it for Mr. Clements' benefit?
He acknowledged that he had the power to either use it for Christopher's benefit or not. But there was an understanding between everybody.
Well, having the power to do it is different from what was the intent of the parties. What was the intent of the girlfriend when she gave the money to the cellmate? Was it so that he would hold it for the benefit of Clements, or was it so that he would use it, hopefully share it? What was the understanding when the money was given to the cellmate?
That he would use it for the benefit of Mr. Clements.
All right.
A plan or scheme or defraud is another way of saying that a defendant hatches a plan with the intent of defrauding another.
Well, let's start there.
Sure.
There was clearly a plan. I mean, we know that because it was stated on the phone calls.
Yes.
So there was a plan, and the plan was to prevent DES from doing one of those administrative orders to secure money from Mr. Clements' account, correct? That was the plan.
There certainly was a plan, and the plan was to take Melissa's money, which she donated for the cause, to be used for its intended purpose, which was to be able to purchase items for Christopher without a concern that Melissa's money would be used to pay something she didn't owe. So that's the plan.
Well, he owed it. Mr. Clements owed it. I mean, don't we start off with the notion that Mr. Clements owed child support?
He did owe child support.
And there was a legal mechanism in place to obtain money from Mr. Clements if he had money put on his account above $50.
If the money belonged to Mr. Clements, if he had earned it.
Well, once it was put in his account, it was his money.
But it was never put in his account.
Was the money oh, I'm sorry. Go
Go
ahead.
No,
ahead.
I was going to say, yeah, but that's the plan, is he was trying to avoid it being taken, so he put it in the cellmate's account. Or he had it put in the cellmate's account.
He put it in there in order to assure that the money that Melissa gave him could be used to purchase items in the commissary and would not be taken from this limited withholding order.
Are you making some distinction between money that he would have earned in the jail versus money that's gifted into his account? Because you said something like, well, it's Melissa's money, it's not money he earned. Is there a case that differentiates those two pots of money where DCSS's withholding orders are concerned?
There are cases which talk about money, gifts of money, and whether they can be used to pay a child support order.
No, I'm not talking about in that. I'm not talking about, we're not in family court. We're
Right.
in the arena of someone's in the jail and has money on their account. So narrowed to that, are there any cases that differentiate between money that an outsider gives to your commissary account versus money that you earn in the jail through work?
There is a case, and it's State v. Torres, which I believe Judge Cruz was on that panel,
About the constitutionality of the statute?
about whether a one-time gift of money by somebody to an inmate is subject to a limited withholding order. That case was not a fraud case. It was a case in which the defendant filed an administrative claim once DES did take the money that his mother gave him. I noticed that neither myself nor Appellee's counsel briefed that case. I came across it while I was preparing for oral argument. I believe, and I'd be happy to talk about that case, as I am, but I would also like an opportunity, if the court would allow us, to file supplemental briefings on why I don't think Torres applies here. I believe Torres was wrongly decided because it failed to understand what a payment is for purposes of determining when a limited withholding order is permitted. 13505A, which talks about limited withholding orders, allows such an order for collection of child support from what it describes as two types of payment. Payment made non-periodically or payment made in a lump sum. But the problem with Torres is, while it did a really good job of talking about what's the difference between a lump sum and what's the difference between a non-periodic, it ignored that general word payment. And payment carries some significance. Payment means the performance of a duty, promise, or obligation, or discharge of a debt or liability. I would argue that a gift does not meet the definition of a payment. And I believe in Torres, the court, if it had used the statutory construction principle of its, I'm going to butcher this, adjustum generis, which says we construe the meaning of a general term within the parameters of the same thing, of the same kind of class as what those statutes expressly mention. If it had used that, it would have recognized that the significance of what is a payment dictates whether it's subject to a limited withholding order. For instance, 25505E talks about lump sum payment, and it says, well, the court did a good job of saying, well, include doesn't mean it's exclusive to this list. And it says it includes things which are, however, in a class as of an obligation owed to a person, or things that arise as an obligation to an employment relationship. I would argue that a gift, again, is certainly not a form of payment, and for that reason, I think Torres was wrongly decided because it missed the point of payment. And second, I think we also need to recognize, as I said, Torres is not a fraud case, a criminal fraud case. It's a civil case that had to do with whether DCS wrongfully took the plaintiff's money. It was not a criminal prosecution for fraud where the defendant elected to have someone put their gift money elsewhere.
You've kind of lost me, because does it require that their DES actually had the authority to take monies over $50, or just the belief that Mr. Clements had that they could do that?
Well, I think the key
Because
is,
isn't that his benefit? Is he wanted to prevent DES from doing it?
but he has to gain a benefit at the expense of someone else.
Okay, well, there's a woman out there who has a child who's entitled to child support.
But she's not entitled to money that Melissa gives for a specific
She's
purpose.
not entitled to go after Melissa's money, but once Melissa gives it to him, Mr. Clements, then she is entitled because it's Mr. Clements' money.
But if she gives it to someone else, it is not a gift to him. It is, well, let me strike that. I'll back up. If she gives it to Macias, then that doesn't represent her defrauding anybody or him defrauding anybody of money that was hers to give as she saw fit.
Except that goes back to what Judge Cruz was asking you in the beginning is, well, she was giving it to the cellmate, but it wasn't for him to use as he saw fit. It was giving it to the cellmate for a specific purpose. And that specific purpose was to allow Mr. Clements to buy items out of the commissary without worrying about DES collecting his money. Right?
Sure. Yeah.
So isn't that a payment to Mr. Clements?
It would be a payment to Mr. Clements, but it would nevertheless, I think, not be subject to garnishment under the limited withholding because it's not for something that is owed or something that she had a duty to give him, not for exchange for property or something like that. And that's the point I was making about Torres.
But for purposes of withholding, does the law draw a distinction as to the source of the funds? I mean, whether the money comes from a relative or, as we were talking about just a moment ago, his earned wages in prison or whatever other source there might be.
Well, I think it does because it's a limited income withholding. And the operative word is income. And if you look at 13,500, which defines income, it defines it as something owed, a payment for something, such as a wage. So I think it does matter.
Are there other unintended consequences of applying the fraud scheme statute in the way that the state did here?
Well,
My imagination's rather limited, but if we take this concept and apply it in a completely different context, is there a place where this lack of limiting principle about what control of money means and whether it's held for someone else or not, can you think of a place where that might be troublesome in another area?
I probably inexpertly tried to draw upon some analogies in my opening brief, but I'll point out a scenario. What if Melissa wanted to give this money to him so he could post the bond? In other words, she wasn't going to post it herself. She was going to put it in his inmate account to post the bond. But he said, look, they're going to take that money for child support, put it somewhere else. Would that be fraud? Because they wanted to use the money to post bond and didn't want it to go elsewhere? I don't think it would. The other example I think I gave is a 401k or some sort of, lack of a better word, a legal tax shelter. Or an example would be if I was out working and my mother wanted to give me lunch money, okay, but I owe child support. And I told my mother, instead of giving me the money directly, give it to my buddy Al, who I go to work with, and he'll buy the lunch. That shouldn't be a fraud scheme. And there's another element of that, which is these are things that arguably are necessities, things like soap, things like deodorant, toothpaste. And I think that kind of factors into it as well.
Well, but no one was preventing him from having money on his books, and certainly if he'd had money on his own books of less than $50 consecutively every single day and got it in and spent it, he would have been able to buy soap and other necessities. So that's not really, we're not preventing him from activities of daily living because he can't have more than $50 in his commissary account on any given day.
Well, there was certainly a testimony to the effect that it would not have been withdrawn if it was more than if it was less than $50, but that was not known at the time. And so, yeah, in reality, he probably would have had enough money to pay for items, but at the time it was perceived that all of that money perhaps could be seized.
Would you agree that he could have been rightly convicted of an attempted fraud scheme?
That's a good question.
She tries to ask good
Yeah,
questions.
they're always good questions. I don't mean they're not, but an attempted fraud scheme would. The thing about fraud is it does contain a specific intent component, which is an intent to defraud.
Well, you've already admitted there was a plan to do
Yeah.
just that. That was the concession you made. I mean, basically in your briefing, but certainly in oral argument.
I would argue that he could not have been convicted of a fraud scheme because, as I pointed out, this was a plan not to defraud anyone of their money. It was a plan to protect assets that Melissa gave him for their intended use. So I would say it was not a fraud scheme or an attempted fraud scheme. The state claimed that it presented evidence that Christopher obtained a benefit by means of a false pretense. But as Johnson notes, a false pretense is not the means to avoid detection, but rather the means by which somebody obtains a benefit at the expense of someone else. The deposit of Melissa's money into the cellmate's account, as a gift, if you want to describe it, to Christopher was nothing other than the means to avoid the detection and seizure of that money so that it would not go to payment for child support that she never owed. The repercussions of holding that this plan represented the means of obtaining a benefit.
Well, hold on, back up.
Sure, Judge.
But that may mean she didn't that she alone could not have been convicted of fraudulent scheme. But he was definitely searching for a benefit, and that benefit was to have money on his account that would not be seized.
And obviously her case is not before us, but she was. But
she could be convicted as an accomplice.
yeah. But your point is that, sure, it was not what she intended, but his perspective is what you're asking about.
Correct.
Yeah, well, his perspective was that I'd be able to buy items in the commissary, and not that the money you want to give me, honey, is going to pay for child support. Yes, I agree.
For our purposes, does his intended use of the money really affect the calculus? Does it matter to us whether he intended to buy necessities or obtain some other benefit?
I think what you're asking, if I can clarify, is
Sure.
Does it matter whether he intended to buy items for the commissary? Isn't it only significant that he wanted to avoid paying child support?
Well, you said that he wanted to use that money to buy things that he needed and gave some examples of those. And my
Right.
question is, does it matter how he intended to use that money? And there are creative ways in which he could have used that money, allowing others, maybe yet another
Well, it
person
matters.
to make purchases and gain a benefit and somehow benefit from that. Does it matter to us how exactly he planned to use that money?
It only matters if, well, what matters is if somebody was defrauded of what was rightfully their cut, okay? But my argument is this was never rightfully their cut, okay? So I don't know if that answers your question, but hopefully. The other thing that the state pointed out is they conceded in their brief that there was no evidence that Clements owed an independent duty to disclose those funds but then claim that the fact that we didn't show that he owed a duty for something that amounted to non-disclosure or concealment was not significant. However, traditionally, an act of fraud based upon non-disclosure has some sort of duty to disclose, and that's in federal cases with the mail fraud statute, and also, I would argue, even Haas. Haas was this Arizona Supreme Court case where even though there was not a formal duty, a fiduciary duty in that case, the court basically found the defendant guilty of fraud because there was a valid expectation that he would be upfront with the fact that the property he used to secure his real estate purchase was worthless. In other words, even though he owed no fiduciary duty to the sellers, his concealment of that fact or non-disclosure of that fact flew in the face of a reasonable expectation of honest dealing with regard to this contractual arrangement. So even though there need not be an official legal or fiduciary duty, there does need to be some sort of duty. And I would argue in this case, there was no duty to disclose that money that Melissa gave to Macias for the use of purchasing items for Christopher.
All right, thank you, Mr. Rossi. Your time has expired. Mr. Smith.
Thank you, Your Honor. May it please the Court, my name is Joshua Smith, Assistant Attorney General representing the state of Arizona. Substantial evidence supports Clements' conviction for fraudulent schemes. The undisputed evidence at trial established that he conspired with his girlfriend to put money into his cellmate's account for the sole reason of avoiding a valid child support obligation. The jury could therefore conclude that he, pursuant to a scheme to defraud, knowingly obtained a benefit by means of a false pretense. I'm going to begin by addressing the benefit aspect. Judge Bailey, I believe, asked if there was any case that addressed this. And I believe Torres is directly on point. And Torres, the defendant, or the prisoner, was an inmate at the prison. His mother gave him a gift. The opinion discusses it as a gift. And it concludes that the gift was a lump sum payment subject to garnishment under 25505A. And it goes on to explain that if he were out, and this is paragraph 18 of the opinion, Arizona law affords ADS a full panoply of remedies to enforce child support arrearage. If Torres' mother had wired her gift to his bank accounts, they could have garnished the bank account. If he were not incarcerated and she had sent him cash that he used to buy property, they could perfect a lien on that property. If he kept the cash in a drawer at home, they could seize the money there. So ADS, DCSS has a wide authority to garnish delinquent child support obligations. There is no real material difference between the prisoner-inmate account in Torres and the jail accounts here in this case.
Since you both addressed Torres, do you think there's any need for supplemental briefing?
No, I believe Torres is directly on point. Granted, Torres wasn't dealing with false pretenses, but the proposition it stands for is that 25505 authorizes the limited income withholding orders in the situation that we have here, which is where a inmate at a jail or a prison receives a gift. 25505 would allow a limited income withholding
Would have
order.
allowed it if it had gone into his own account.
Yes, had it gone into his account, DCSS would have been aware of it, and then the evidence is that they could have garnished it, but the only reason they didn't garnish it is because they were unaware that the money was available to him.
Wasn't the testimony also that they wouldn't garnish an inmate account below $50?
Yes, the testimony was that any amount in excess of $50 would be garnished. So Clements received a benefit at the very least of $20 from the $70 deposit that was made on June 18th of 2017. But the jury also could have reasonably concluded that the amounts could have accrued to over $50. And one of the jail calls, Clements notes that he had some money left over. So while only one deposit alone was enough to reach the threshold for garnishment, the jury still could have found that the amounts total could have aggregated to over $50 and some additional funds could have been garnished had it gone into his account.
Mr. Smith, I have a question that's kind of an extension of what Mr. Rossi was conceding basically that there was a plan and that the cellmate held the money for Mr. Clements' benefit. And my question is the idea of control an issue here in the sense that it was Melissa's money to control what she did with it, and she chose to put it in an inmate's account, and that it was up to the cellmate to share that money. Had he chosen not to, it was in his account. I think the testimony was pretty clear that while it's a habit for cellmates to agree to share money in their commissary accounts, they're not allowed to transfer it to another inmate. If Melissa had deposited money on April 1st into Mr. Macias's account, and then Mr. Macias was transferred to DOC, that even if Melissa's intent was that it be held for Mr. Clement, that money would have left the jail with Macias, and Clement wouldn't have had any control to keep it. So I'm just concerned around the area of what we're doing when we say Melissa has money that she's putting somewhere that isn't in his account, it's in a cellmate's account. The cellmate has to then be the one to agree to share it or to hold it or to allow him to fill out commissary forms to receive items. He's never had control over where this money goes or what happens to it.
I have two answers to that. First, I would disagree that he never had control. He directed Melissa to put the money into Macias's account.
Right, but it was up to Melissa to do that. He could not, he was in jail. He couldn't put a gun to her head. There's no evidence that he threatened her. He said, put the money in my cellmate's account instead of mine. It was her choice what amounts. We see she gave different amounts on different days. That was up to her whether she was going to do that, correct?
Yes, Melissa could have decided not to.
Sure.
And then my second answer is that the definition of benefit includes prospective benefits. So even if the money had gone to Macias's account, but then Macias either didn't spend it on Clements or was then sent to prison and couldn't spend it on Clements, there's still a prospective benefit there in that the money is going in there because Clements is expecting that he will have those funds available to him and those funds would not be subject to garnishment. So the definition of benefit includes both what's actually received and the prospective benefits, but in this case, Clements actually received the benefit. But even if Macias refused to participate or was transferred to a different part of the jail or sent to prison, there's still the prospective benefit that Clements received because he was expecting that the money would go on to would be available to him. Regarding the third element of the fraud scheme statutes, the false pretenses, Mr. Clements argues that there has to be a duty to disclose, but the duty to disclose is only required if the liability is premised on the theory of material omissions, and that was never the state's theory. The state's theory was that it was a false pretense or a misrepresentation. And here, by directing that the money be placed into another person's account, Clements was concealing the fact he had money. So this is not a passive concealment. This is an active concealment by directing that money be placed into a different account. It'd be akin to if he was out of prison, either having someone pay him under the table so that way the income's not reported at all, or sending the money to an offshore bank account or some other way in order to, it's akin to laundering the money is what he's doing. But by having the money deposited into Macias's account, he is actively concealing the money, and by doing so, it is facilitating his acquisition of the benefit, which is the funds that are available to him that
So should family court litigants be running scared if this conviction is affirmed? And I'm talking about people who don't marry their longtime boyfriend because doing so will stop their spousal maintenance. I'm talking about someone who isn't working and is being supported by a woman, a spouse, a girlfriend, a boyfriend, whoever, that's giving them money. So they're living the high life, but they're not paying anything in child support, which could be seen as they're getting lots of benefits. They're getting a roof over their head, they're getting a vacation, they're getting their car payment and gas paid, but the child's getting no money. So is this an area where the county attorney is going to reach in and say, we're going to be charging fraud scheme?
I don't believe so because the state still has to prove all three elements, and the first element is a scheme to defraud, which requires an intent to defraud. So unless you can show in a situation that they're not marrying and solely for a fraudulent purpose, solely to avoid this, I don't believe that is.
What if they're open about it? I'm not marrying him because when I do, he's going to have to stop paying spousal maintenance, and I'm being plenty supported, but I'd like to see him suffer every month by writing that check. Or the other scenario with the child support, where it is someone owes child support and they're with somebody, whether it's a parent who's lavishing money, a significant other, and they're having all their needs met and the child's having none. And they've got a court order just like here, and they have access to money that they could be using to the benefit of the child.
Well, again, there still have to be a fraudulent intent. People can voluntarily choose not to earn more money. In a situation where people are trying to game the system, there are mechanisms in place in the family court where they can try to get a modification saying that they actually, to say that this is income. I believe the Cummings case that Clements cites in his reply brief is that kind of situation where mother is receiving regular gifts from her parents, and the court modified the child support order saying, well, this is income now available to her. So there are mechanisms available in the family court, but in terms of the criminal prosecution, the state still has to meet all three elements. They'd have to show that there is a fraudulent intent, they have to show that there's a benefit being obtained, and they would have to show that there's some false pretense or material omission or false promises or false representations that are being made that facilitates acquisition of the benefit. So the statute is broad, but the statute's broad because the range of fraudulent activities is broad, but the state still has to prove all three elements beyond a reasonable doubt in order to obtain convictions, and would have to have a reasonable likelihood of proving all three elements beyond a reasonable doubt before they even bring in charges. So I don't think that is a concern that the county attorney's office will be looking for people who are trying to game the family court system. In this situation, the undisputed evidence was this was done solely to avoid this valid child support obligation. Clements was aware of this valid child support obligation. He did not want to satisfy it, and he had his girlfriend place the money into Macias's account purely to avoid having the money subject to garnishment. And as a result, he obtained the benefit, and the benefit came at the expense ultimately of his son, to whom he owes the spousal or the child support order. ARS 25501C says that child support is the primary obligation, and all other financial obligations are secondary.
What about the spouse who doesn't notify his or her former spouse that they've remarried, thereby terminating the spousal maintenance obligation? So they keep receiving the spousal maintenance obligation even though the marriage has taken place.
Again, there have to be some evidence that her failure to disclose or his failure to disclose was a scheme to defraud, or there's some fraudulent intent. And the scheme or artifice for the purposes of the statute is some plan, device, or trick to perpetuate a fraud, and it has to be done with the intent to deceive persons of ordinary prudence. And the intent can be established by proving the defendant devised the fraudulent scheme or willfully participated in it, knowing its fraudulent nature. So
there had to be some type of duty to disclose that she remarried.
If the liability was premised on material omission, yes, or there would have to be some sort of false pretense that's being used or some sort of false representation.
If there's a duty to disclose in that context, why isn't there a duty in this context?
There may well be a duty, but the state's theory below was never that there was a duty to disclose. The state's theory below was that Clements was falsely representing that he did not have these funds available to him or money available to him that could then be used to satisfy his child support obligation. He's actively concealing the money. And the evidence at trial was that had the money been placed into his account, DCSS would have issued a limited income withholding order, and then the money would have been subject to garnishment. The state's theory was never relating to whether he had a duty to disclose the funds to DCSS or to the mother of his child in Oregon. The state's theory was always that this was a false pretense. So the state's failure to show a duty to disclose is not fatal to this case. Material omission is merely one way to obtain the benefit under the statute. The language is a person obtains a benefit by means of false or fraudulent pretenses, promises, representations, or material omissions. So the statute is disjunctive. So material omissions is merely one way, and you would need some duty to disclose if you're premised your liability on material omissions. The state didn't do that here, so the state was not required to show a duty to disclose. And so Clements' argument is the state's failure to do so is fatal, but because it's a disjunctive statute and the state's theory was never material omission, the duty to disclose was not required to be shown to sustain the conviction here.
10.5 years for $20?
Well, the 10.5 years is largely because Clements was a Category 3 repetitive offender. I believe the court found 10 prior felony convictions, and ultimately that's a question for the legislature to decide whether they think fraudulent scheme should be Class 2 felony in all circumstances or whether it should be graded similar to the theft, but that's ultimately a legislative decision. And his sentences are also concurrent with a life prison sentence for a murder conviction in Tucson and longer prison sentences for the burglaries. I forget the precise length of the burglary convictions, but his 10-year prison sentence is concurrent with other convictions that are longer. But the length of the sentence is driven primarily by his extensive criminal history, not simply because it's $20 or simply because it's a Class 2 felony. If there are no other questions, the state would ask that this court affirm Clements' convictions. Thank you.
All right.
Thank you.
Thank you, counsel, for your briefing and your argument. The matter is deemed submitted. We'll issue a decision in due course. The court's in recess.